Hello everybody, and once again my name is Colin Crockett, brother of Cameron Crockett, and this is the third time I'm coming to you in regards to the case of Cameron Crockett versus the Commonwealth of Virginia. And today we have some pretty interesting facts and points and key factors that basically support the defense's innocence, and I'm going to go ahead and start reading off some key factors and things for you that back up thus far. It was Pamela Patrick that testified that her back was turned to the street as she heard the impact, and she could not find the car at first because of two parked cars directly in front of the car's final point of rest. She further testified that when she stepped off to her porch to try and find the vehicle, she spoke briefly with Antoine Smith, who was standing on the sidewalk in the front of her yard. It was only after she saw the direction in which Smith was looking did Pamela Patrick ever first lay her eyes on the car up against the tree. And it was, according to her own testimony, no shorter than a minute before she was able to physically get to it and observe the remaining occupants. Thus, Ms. Patrick absolutely cannot be said to be a witness who rules out or precludes that a third person and true driver fled the vehicle in a mad dash and took cover in the dense woods on that side of the Wolf's Neck Road. And because of this incontrovertible fact, Ms. Patrick absolutely does not rule out every reasonable theory of innocence in this case. However, Ms. Patrick's testimony concerning the defendant's position in the vehicle upon her arrival could have and certainly should have been considered exculpatory evidence by the jury, but was apparently ignored. Patrick was the first witness to arrive on the scene. Observed Mr. Crockett as unconscious, kind of laying curved in the back window, with his left arm protruding from what was the rear windshield of the vehicle. His upper torso on the right side of the back seat, his head turned down and his feet flush with the driver's window inside the car, laying on top of the somewhat broken back driver's seat. Through the details of this observation, it is most obvious that the defendant's body was first found entirely behind the two front seats, as even the defendant's feet were not down in the driver's seat or under the steering wheel, but actually on top of the headrest of the driver's seat. The only natural classification for this sort of positioning is that he was, when put simply, the one in the back seat, and this is exactly how Pamela Patrick described the defendant while on the phone with 911 just minutes after the accident had occurred. She offers zero evidence that Mr. Crockett was the driver, can't rule out the defense's theory of innocence, and actually boosts the defendant's case when considers Newton's first law of motion, which dictates in most basic terms in this crash that the occupants would have been thrust rightwards, not backwards. The defendant was first discovered in the back seat because that is exactly where he was seated immediately before the accident. Witness number 2, James Kelly Reed's, sequentially the second individual to reach the vehicle against the tree, testified that it took him about a minute to a minute and 5 seconds to get there, and stated that he was running in response to the loud noise he had heard. He did not maintain a clear and constant visual of the accident site. He, too, upon arriving at the vehicle's final point of rest, observed Mr. Crockett in the back seat, unconscious, with his arm protruding from what was the rear windshield of the vehicle. After Pamela Patrick and James Reed, not a single witness, resident, rescue, or otherwise, saw the defendant in his original unconscious position in the car as a direct result of the physics of the accident. And it is precisely for that reason that after these two crucial witnesses, no other witnesses are in complete agreement as to how they describe having seen Mr. Crockett. James Reed very clearly testified that only seconds after he got up to the vehicle, he witnessed the defendant start to wake up and move around, shifting his position in the vehicle as he was, according to the witness's perception, trying to self-extricate. This is a very simple fact, quite possibly the most important one of the entire case, as it proves beyond the pale of any doubt whatsoever that Mr. Crockett absolutely did not wake up and begin moving and shifting his position in the vehicle before witnesses such as the Dickinsons and the responding police officers saw him. So as for Mr. Palmer's little made-up story about how Mr. Crockett being smart and jumping into the back seat after the collision to make it look like he was not driving was just refuted by the first two actual witnesses on the scene that the prosecution themselves put on the stand. Nothing more unreasonable than for the jury to consider any part of Mr. Reed's testimony as inculpatory, for he, like Miss Patrick, offers zero evidence that Mr. Crockett was driving, got to the vehicle too late to rule out a fleeing driver, and provides two angles of exculpatory evidence. One, that Mr. Crockett was found in the back seat, and two, that he was also definitely moving about within the car before any witnesses responded to the scene. Third on the scene was Joe Daniels, the then roommate of the Dickens at 2140 Wolfsnare Road, where the accident had occurred. Daniels, just like Pamela Patrick and James Reed, was reminded by his 2009 interview with investigator Stephen Powell that he, too, first classified Mr. Crockett as having been in the back seat upon his arrival at the scene. Though it was not revealed explicit in the trial, Mr. Daniels states in the same January 2009 interview with Stephen Powell that James Reed was out there before him. As a natural conclusion, Mr. Daniels did not get to the scene fast enough to rule out a fleeing driver, offers zero evidence that the defendant was the driver, and his observations of the defendant as having been in the back seat further bolster the defense's theory of innocence. Fourth on the scene was Colton Dixon. He started in trial that it took him 1 to 2 minutes to get outside and up to the vehicle, but given his other testimony, one might hypothesize that it may have taken him even longer. Mr. Dixon stated that he had to not only get clothed after he heard the impact, and that he and Mr. Daniels were fumbling with the keys trying to unlock his front door, but that after he only very quickly peeked outside, he decided to stay outside to call 911. During that 911 call, he told the operator that he just looked outside real quick, and that someone had actually struck the two cars parked outside his house. Descriptions which combined to evidence that the fact that Mr. Dixon absolutely did not have a clear, constant, or even considerable visual of the accident site before he went out to the car some minutes after hearing the impact. Furthermore, Mr. Dixon testified that he saw 5 to 7 people outside around the car by the time he even got outside, a fact which, as if any doubt remained as to whether or not he saw Mr. Crockett as he first found him as a direct result of the physics of the accident, totally removes him from the equation as a witness whose observations of the defendant bear any weight in determining where he was seated before the accident. Because of this, it rings thematically true that Colton Dixon offers zero valid evidence that Mr. Crockett was the driver, and simply cannot rule out the prospect of a fleeing third person and driver. Fifth and last of the Wolfsnare Road residents to arrive on the scene was Holly Dixon, Colton's wife. Mrs. Dixon is quite possibly the most insignificant Commonwealth witness in this entire case, as she testified it took her 2 to 4 minutes to actually get out to the car. In truth, Holly Dixon testified that it took her this long to respond because she was actually sleeping at the time of the accident, and after hearing it, had to get dressed head to toe before she was even able to proceed downstairs. Yet again, here we have another witness that offers zero valid evidence that the defendant was the driver, and definitely cannot rule out a third person fleeing. Aside from the lay witness responders, Officer Buchner and Bradley were among those officers responding to the scene chosen by the prosecution to testify in this case. Officer Buchner was the first police officer to arrive on the scene, but James Reed testified in court that police didn't get to the scene until about 5 minutes after he had gotten there. Additionally, in more exact terms, the CAD dispatch records for this case represent that Officer Buchner wasn't even paged out to respond to the accident for at least a minute after the first call that came in, which was naturally some amount of seconds after the car struck the tree. Buchner's own testimony tells us how long it took for him from the point at which he was paged to the time that he arrived on scene, about 90 seconds. Simple math reveals that it took Officer Buchner about 3 minutes to actually get to the scene of the accident. This leads us to one very elementary yet vital conclusion, that by the time Officer Buchner laid eyes on Mr. Crockett, the latter had been conscious and moving around within the vehicle for about 1 to 2 minutes. More than ample time for Mr. Crockett to have shifted his position in the vehicle so significantly that every witness who saw him after James Reed had described his position in a different way. Officer Bradley's testimony is equally inconsequential, as he arrived minutes after Officer Buchner. although the only two witnesses in agreement as to Mr. Crockett's position in the vehicle are the two that arrived at the scene, Patrick and Reed, and although all the witnesses who sequentially followed the first two in their response to the accident have testified to differing descriptions of Mr. Crockett's in the car. Those witnesses having arrived after Mr. Reed do share one thing in common. They all bear no weight whatsoever in the jury's determination of guilt or innocence in this case in trying to conclude based on where Mr. Crockett was originally found in the car, where he must have been seated just prior to the accident. Between Officer Buechner's and Bradley's and the Dickens couple, it is nothing less than insane for a jury to believe that any of them bear any inculpatory evidence whatsoever against Mr. Crockett. It is equally insane for the jury to believe that any of the four of them could rule out Mr. Crockett's theory of innocence, which is that a third person and true driver fled from the scene far too hastily for any of the responders to have seen him escape. On the other hand, the prosecution's own witnesses, Miss Patrick and Mrs. Reed, and to some extent Mr. Daniels, actually corroborate the defendant's theory of innocence in more ways than one. The prosecution has always been well aware of this fact, and that to remedy the lack of evidence that Mr. Crockett was driving as concerns these 7 witnesses, they have made the pitifully weak attempt to sealing Mr. Crockett's fate as the alleged driver by presenting before the court an individual we know as Antoine Smith, who the prosecution argued in its opening would tell the jury she saw it all happen, and that no one got out of the car. However, as it was revealed in trial, Antoine Smith's credibility is as rotten as the apple that hit Isaac Newton in the head centuries ago. She claimed that she saw it all happen, yes, but she also claimed standing right by what would become the site of the accident, her attention was caught by the light at Great Neck Road in Wolfsnare, almost a half a mile away, turning green. The defense brought in 2 experts to survey the area and determine if it was even possible for Antoine Smith, standing where she said she was standing, to actually seen the light turn green. And their study proved without any argument that it was impossible for her to have seen what she said she had seen. In a desperate attempt in the prosecution's rebuttal closing to sway the jury, Carrie Kopnicki reminded us that the survey was worthless and Antoine Smith's credibility restored because Miss Smith told us on the stand that she didn't see the actual light turn green, but that she miraculously saw the light's reflection in a puddle of water next to her. For this argument to have actually been bought by the jury, there should leave no doubt in the court's mind that the jury must have been completely unreasonable, as even the most uneducated of blokes can tell you with complete confidence that as the road bends leftward and rightwards for roughly 0.4 miles, and that sight of the light itself is lost before the first tenth of a mile, it is even more impossible that Antoine Smith saw that light's reflection. Absent from the prosecution's rebuttal closing, though, wasn't in any argument that, as a fact that Mrs. Smith stated she was as sure as anything else. She has told us that the car spun around and then whipped around in a half rotation before it struck the tree. The reason why the prosecution failed to counter this is the same reason why they knew they could not expose Officer Kellogg to the stand. For it was the lead investigator, Kellogg's own crash diagram, that showed very clearly that the car did not spin around once or twice and a half, but rather did it simply slid 149 feet and 9 inches. It was the defense that brought this unacceptable contradiction before this court's attention, and the fact will always remain that, through this diagram, crash scene photos, and other witness testimony, the car simply slid, and that Antoine Smith apparently hallucinating this recollection, unless of course there is more sinister explanation for her blatant lies. What Antoine Smith really saw that night that has caused her to perjure herself so thoroughly on the stand before this court, this Commonwealth, and our God? Certainly no reasonable jury could have even considered Antoine Smith's testimony as the least bit corroboratory that Mr. Crockett was the driver. The final witness that the Commonwealth feebly offered in attempting to prove Mr. Crockett was the driver was none other than Officer Walter Wallace, who interviewed the defendant in the hospital almost exactly 1 hour after the accident, yet his testimony and the recorded audio tape of the interview with Mr. Crockett far from proving Mr. Crockett was the driver, actually corroborates one pivotally particular element of Mr. Crockett's theory of innocence. This is that he was experiencing an amnesia for the traumatic event and could not recall for the accident, and clearly demonstrates how poorly this portion of the police investigation was performed. Prior to that interview, Officer Wallace's own late December 2008 inter-office memorandum to Officer Kellogg confirms that Officer Wallace first made contact with the defendant at 12:15 a.m. that morning, and he started the interview only 2 minutes later at 12:17 a.m. Officer Wallace's testimony confirms that he did not consult one single EMT, nurse, doctor, or anybody about Crockett's mental condition before only waiting 2 minutes to interview him. Officer Wallace was so careless in his thought process that he testified to the fact that he noticed glass in the defendant's hair, but it somehow never occurred to him that it is highly consistent with a recent head injury. He also noticed that the defendant reeked of alcohol and exhibited all typical symptoms of intoxication, but it evidently never occurred to him that this intoxication, along with the possibility of a head injury, might have, and in this case absolutely did have, impact on the defendant's recall for the traumatic event and the event's immediate preceding and succeeding it. During the interview, never does Officer Wallace ask the defendant if he was the driver, nor does Mr. Crockett ever state that he was the driver. From the start, the defendant is heard telling Officer Wallace that he cannot recall the accident, what street it occurred on, or what were the circumstances the accident occurred. Unfortunately for the defendant, when he asked Officer Wallace what had happened and where it took place, the officer actually deliberately lied to the defendant on 2 separate occasions, further confusing him. When Officer Wallace, at the end of the 7-minute interview, asked Mr. Crockett if he had anything further to add to the conversation, Mr. Crockett responded with, "I was in an accident? In what sense?" Following this interview, Officer Wallace never once attempted to record another one with the defendant in the hours and or days after the first one, when Mr. Crockett might have sobered up or gained some recall from the traumatic event. Officer Wallace, like the prosecution witnesses that came before him, offers zero evidence that Mr. Crockett was the driver, and, as we have outlined, serves to confirm that Mr. Crockett could not recall the accident at the time of this interview. How could any reasonable jury trust Officer Wallace's testimony to be sufficiently inculpatory to judge Mr. Crockett as guilty? Probably one of the most important key factors of the case was the police failures. They can be categorized in 3 ways. We have the failures on the scene to properly interview and process witnesses and soundly evaluate their statements, their failure to properly interview the defendant and further investigate circumstances of the accident following the accident, as we have already elaborated on, and perhaps the most importantly, their repulsive failure to preserve key evidence. On the scene, it should have been very speedily and easily determined that Mrs. Patrick and Mr. Reed were the first 2 witnesses on the scene, and that they had saw Mr. Crockett in the back seat, which is definitely exculpatory and should have been seen immediately as the least potentially exculpatory, as it is far from difficult to apply Newton's simple first law of motion. It was also obvious on the scene that the car slid, yet the police apparently never picked up on the huge contradiction to this established fact in Antoine Smith's statements to the police, which is just inexcusably inept police work. Even more reprehensible is the fact that the police officially left the vehicle, which is doubtlessly evidence in this case, completely exposed to the elements for at least a number of weeks, which led to the erosion of DNA evidence on the objects in the car. The most important of these things contained within the car was what Bob Bagnell described as the only smoking gun class evidence in a case such as this, the driver's side airbag. Commonwealth agents include Officer Kevin Joseph Kelly admitted on the stand that airbag was pulled on February the 12th, 2009, some 6 weeks after the accident, but that it was never sent off for testing because of its exposure to the elements and the subsequent deletion of the most critical DNA evidence in the form of blood and saliva on that airbag. This is a mishap so unpardonable because it is the one solid, hands-down piece of evidence that could have completely acquitted Mr. Crockett of being the driver and actually shown Jacob Palmer, had the DNA sample from the airbag been properly preserved, to be the true driver and true killer of Jack Corte. Additionally, Bob Bagnell testified to the importance of preservation of the defendant's clothing, which, he had been the driver of the car, would have retained certain particulate matter on it from the driver's side airbag. However, the jury was denied access to these and other pieces of evidence, all because the police failed to do their job. A reasonable jury absolutely could not have found Mr. Crockett guilty in the face of not only an abyssal lack of valid circumstantial evidence to the effect, but more importantly, of a physical evidence. The second key element of the defense's theory of innocence is, naturally, that the defendant was not driving the car at the time of the accident, but that a third party who fled the scene was. This element is primarily supported by the defendant's testimony and piecemeal memory photographs of the vehicle at the scene of the accident and at the fire station later on in the morning, and the position in which he was found immediately following the accident, which has already been covered and does not need to be repeated. The defendant has testified that he does not recall the accident and did not recall the accident at the time of the interview with Officer Wallace, and he also have EMT Beth Cowling's testimony that Mr. Crockett also actually asked her numerous times while in the ambulance on the way to the hospital 10 to 15 minutes after the accident what happened. We heard from Dr. Maples, the ER doctor who oversaw Mr. Crockett's admission and treatment after the accident, who told us that although a patient can be alert in following commands or reciting very long-term memory information such as one's name, social security number, or date of birth, that patient could also still very well be experiencing amnesia for a traumatic event. We heard from Dr. Kohler, who confirmed that it is not just possible but not uncommon for patients who hit their head hard or who have their brainstem shaken violently enough within the skull to experience amnesia for the traumatic event, and also that it is not uncommon for those patients to, over time, regain or recall some for the recall for the event for some moments surrounding it. We also, of course, heard extensively from the defendant about the memories that had returned to him since the accident, which include a memory of a conversation with Jacob Palmer in which getting a blunt wrap was discussed, and Mr. Crockett opted not to drive but instead to offer his keys to Mr. Palmer as compensation for his supplying the marijuana and money to buy the papers with. One of being outside the car in the parking lot where the party was being held, in which he offered the victim the front seat and was asked by someone else for a jacket, and two memories of being in the back seat en route to the store to buy those papers. It was further established throughout trial, corroboratory to Mr. Crockett's testimony, that neither Mr. Crockett nor Mr. Corte had any money, and it was consequently argued that without money and without a third person to drive them, Mr. Crockett and Mr. Corte would not have any reason to ever leave the party, then to return to it in the space of about 15 minutes along a route and time frame consistent with going to the store for a quick purchase. The prosecution's own photographs, taken both at the scene of the accident and at the fire station following the extrication of Jack's body some hours later, depict a collection of points very favorable to the defense's assertion that Mr. Crockett was not the driver of the car at the time of the accident. For example, numerous pictures show general views of both the driver's side and passenger side of the vehicle which struck the tree. The driver's side is shown to be very much intact and with no intrusion from the tree. The driver's side window is also clearly shown to be the only down, not shattered out window. With the driver's compartment intact and the window down prior to the accident, it becomes quite evident that a belted driver could have easily survived the accident with little injury and bolted out and down the driver's window. The photos of the passenger side of the vehicle show us that the tree stopped just short of the rear right quarter panel guarding the back seat, quite literally smack on the T-frame that separates the two compartments. Photos looking in the rear right compartment from the driver's side also show just how intact this part of the car remained after the accident. One photo in particular, taken from the passenger side of the car, shows the broken back front passenger seat headrest in the rear window, with which very little room separating it from the back seat itself. Interestingly enough, Officer Buechner testified to the defendant's head and shoulders were fully behind the broken back front passenger seat, a description which, if accurate, puts Mr. Crockett's upper torso in so small a compartment that one is compelled to conclude that he did not fly there against the laws of physics, but because he was there to begin with. Two other crucial photographs that are taken at the scene of the crime depict a black jacket laying on the ground maybe 5 yards behind and to the right of the car, close to the adjacent home's driveway. The prosecution's own case included testimony from EMT James Dickey, who was responsible for drafting the pre-hospital patient care report for Mr. Crockett and was also with the defendant in the ambulance, testified that he cut away a shirt away from Mr. Crockett, but never a jacket. His PHP-CR reflects his testimony and clearly shows that there was never any jacket taken off the defendant at any point in time during the treatment on the scene. The prosecution's own case also included testimony from Dr. Samantha Wexler, who examined Jack Cortez' body that morning after his tragic death. The doctor testified that she did not find any jacket on Jack at any point in time during the examination of his body. These things considered, the 800-pound elephant in the room can't help but stomp loudly, for if Mr. Crockett and Mr. Cortez were both without a jacket, and if Mr. Crockett remembers someone asking him for a jacket before leaving the parking lot of the party, who else but that third person and true driver in his flight could have shed it on the ground there? The forensic unit took photographs of it precisely because they thought it was important enough evidence to be properly documented, but did the police ever process this jacket for shards of glass or blood or perhaps particulate matter from the driver's side airbag? They did not. And it was actually just thrown back into the trunk of the vehicle when the scene was actually being cleaned up. For a property and evidence voucher for January 7, 2009 shows that it was taken out of the vehicle by the defendant's mother and her friend on that day. Only Jacob Palmer could have left that jacket there where it was found and photographed on the path down Wolfsnare Road towards First Colonial Road, on the side of the road where the woods are, but yet yards away from the road. This piece of evidence alone should have provided more than enough reasonable doubt for a true finding of a not guilty, and it was for this reason that it was never once refuted by any theory proposed by prosecution in the rebuttal closing. Photographs from the fire station post-extrication was shown several points favorable to the defense. Among them is one which shows a spot of blood on the rear right back seat, which corresponds to where Miss Patrick and Mr. Reed remember seeing Mr. Crockett, and also with Mr. Crockett's own recollection of sitting in between the middle and right back seats. The same photograph shows extremely well that the tree's intrusion stopped at the T column and at the left in the rear right quarter panel, and therefore the back seat intact. Upon examination of this and other previously mentioned photographs, it becomes resoundingly clear that with the driver's compartment intact and its window down, and with the back seat protected from the intrusion of the tree into the vehicle, a belted driver could have in fact did survive the accident with little injury and fled into the woods, and that an unseatbelted back seat passenger, in this case the defendant, could have in fact did survive the impact from that safely cocooned compartment also with little injury. Well, I hope you guys are ready for this because I've saved the best for last. The third and final key element of the defense's theory of innocence takes the second one a bit further with a conspicuous amount of corroboratory evidence and testimony. This third element is that Jacob Palmer, the coward who has in more than 3 years never once dared to show his face before his honor in this noble court, while the defendant has appeared at dozens of hearings and testified in his 2 felony trials, was that third person and the driver of the car when Jack was killed. Through phone records obtained by previous counsel in the case in March of 2009, we have come to find out a couple hours before going to the party, Mr. Crockett texted Mr. Palmer. Now pay close attention to all these phone records because these all tie into the things I've been saying. Mr. Crockett texted Mr. Palmer about going to that party just as the former testified to on 2 separate occasions. These records also show at 10:45 p.m. that night, Palmer contacted Mr. Crockett inquiring as to his whereabouts, and that at 10:50 p.m. Mr. Crockett responded by telling him he was in the parking lot and that he was waiting for him to come outside and show Mr. Crockett and Mr. Cortez which apartment the apartment was being held at. Now, Mr. Crockett testified that he remembers staying at the party for only 10 to 15 minutes before the 3 of them all decided taking his car to get a blunt wrap. Other witnesses confirmed that Mr. Crockett and Mr. Cortez did not stay long at that party. Jacob Palmer's phone records indicate that at 11:06, 16 minutes after Mr. Crockett and Mr. Corte entered the party, Mr. Palmer texted one host of the party, Joshua Reddy. Joshua Reddy confirmed in his testimony that, quite naturally, Mr. Palmer was not inside the apartment when he sent him that text. From this, one can only conclude that Jacob Palmer left that party no later than 11:06, and that his timing coincides exactly with when Mr. Crockett and Mr. Corte had left the party. Josh Reddy went even further in his testimony in pointing the finger directly at Jacob Palmer. Mr. Reddy testified, although he did not see any of the three men physically leave the apartment and go out the front door because of the fact that a deep stairwell blocked the view of upstairs guests to the front door itself on the floor below. He noticed at once that all three of them had left. Mr. Reddy also testified more specifically that the time Jacob Palmer was gone from the party was the same time that Mr. Crockett and Mr. Corte had also been gone from the party. Mr. Reddy, perhaps more critically than anything else, stated before the court that right before he left, Mr. Palmer asked Mr. Reddy what he wanted from the store, something which absolutely cannot be seen as mere coincidence when Mr. Crockett had testified that the whole purpose of leaving the party was go to the store to get a blunt wrap, and when we know by phone records and by Mr. Reddy's testimony that Mr. Palmer left the party at the same time that Mr. Crockett and Mr. Corte left. We also heard testimony from Amarel Barreto, the fiancée of the other host of the party, Kevin Rondorf. She stated that there was a time during the party when she witnessed Mr. Crockett, Mr. Corte, and Mr. Palmer all talking together, and that shortly after this, there came a time where Mrs. Barreto, though she did not see any of them physically leave the party, noticed at once that, just like Mr. Reddy, that all three men had left the party. Additionally, Mrs. Barreto stated that she heard Jacob Palmer say, just before he had left, that he was going out for a smoke, something else which cannot be considered a coincidence when we know very well that the purpose of the trip was to purchase a blunt wrap to smoke a marijuana cigarette with. Furthermore, Mrs. Barreto testified that some hours later, Mr. Palmer returned to the party acting weird and sketchy and very concerned about Mr. Crockett and Mr. Corte, and that he had asked the people still at the party if anyone had seen them or been able to get in touch with them by phone. Jacob Palmer's phone records indicate heavy contact between him and the two hosts of the party from 11:06 p.m. all the way up to 3:19 a.m., which indicates that this is likely the time frame during which he was gone from the party. Those records also, curiously enough, show that Jacob Palmer called the defendant, called Cameron twice right after the accident at 11:19 and once again at 11:25 p.m. before calling him again at 3:10 a.m. and texting him at 6:29 a.m. Though the defense called Jacob Palmer as the true driver of the defendant's car the night of the accident from the outset of proceedings, not just in May of 2011 at the first trial, but again at the February 2012 trial, and though the defendant himself willingly took the stand both times for 2 hours, the prosecution failed in both trials to ever once call Jacob Palmer in rebuttal to the well-founded allegations put against him. His Honor must be informed that Jacob Palmer was first subpoenaed by the prosecution in November of 2010, 6 months before the trial even started, and that this subpoena was the only subpoena in 3 years to be served to a witness at the courthouse itself. It was here that Mr. Palmer is believed to have been first interviewed by the prosecution. Tabitha Anderson confirmed to Andrew Sachs that Carrie Kopnicki herself performed the 2 of the 3 total interviews completed with Jacob Palmer. Your Honor, asked the prosecution where Mr. Palmer was in the first trial in the wake of their failure to put him on in rebuttal, and Carrie Kopnicki told His Honor that she would tell him why Mr. Palmer was not called after the verdict, something which this defendant highly doubts was a promise ever kept. Tabitha Anderson then went on to argue in closing that we just found out this week that Jacob Palmer is a real person, but every shred of evidence available to this court strongly suggests that that statement was a bold-faced lie. As it was revealed in the first trial during Josh Reddy's cross-examination, Josh Reddy was not only interviewed by Officer Kellogg in April of 2009, but Mr. Reddy was specifically asked about the nature and duration of Mr. Palmer's absence from the party, a fact which clearly shows that the prosecution and police knew from a very early point in time that it was Mr. Palmer in the crosshairs. As a result of the foolish disclosure by the prosecution, the defense in January and February in 2012 filed a supplemental motion for exculpatory evidence written in chief by the defendant and received Mr. Palmer's 3 interviews with the prosecution and its agents, as well as interviews with other individuals at the party that night. Though rich with information favorable to the defense, these documents and their contents were unable to be introduced to the court because of Mr. Sachs refused the defendant's constant pleas to put Jacob Palmer on the stand at the end of the defense case as a hostile witness in order to bring to the light, after all this time, his numerous commending contradictions and lies collected by interviews conducted by both the prosecution and the defense. The defendant first made it clear to Mr. Sachs that he wanted Mr. Palmer to be exposed to the stand in October of 2011, in preparation for what was a scheduled November 1st, 2011 trial. Following the continuance, which put it off until February 2012. The defendant met with Mr. Sachs in excess of 10 times, and the topic of Mr. Palmer being called to the stand as a hostile witness was discussed at all but one of those meetings. Mr. Sachs consistently voiced his disapproval of the strategy as too risky, despite recognizing its merits and potentially massive benefits. Again, on the morning of Wednesday, February 29, 2012, Mr. Crockett pleaded with Mr. Sachs to call Mr. Palmer to the stand, but Mr. Sachs would not even take into consideration his position. It was because of his failure to call Jacob Palmer to the stand that certain vital exculpatory evidence and information was never brought before this noble court, and it is along these lines that this defendant motions his honor to, if he will not enter an outright acquittal and overturn the verdict based on the facts already discussed that were introduced to this court through the course of both trials, set aside the verdict and grant a third trial on the grounds that the verdict was contrary to the evidence presented of ineffective assistance of counsel, and on the grounds that new evidence unknown to this court was never presented as a result of that ineffective assistance of counsel. There is literally zero evidence that my brother, Mr. Crockett, was the driver when Jack was killed, and that there is in fact an abundance of evidence to support the fact that Jacob Palmer was. The judge wanted to know where Mr. Palmer was in May of 2011 when the judge asked Carrie Kopnicki why she did not call him. Your Honor, the judge wanted to know where Mr. Palmer was in October of 2011 when this defendant's, my brother, emotions overflowed and life momentarily collapsed in a flurry of 19 phone calls to Mr. Palmer, in which he was threatened him with harm, not if he did testify, but if he did not testify. Your Honor, the judge told the prosecution that you would actually rehear the motion to revoke this defendant's bond if and only the prosecution brought forward Jacob Palmer to testify in the matter. But did the prosecution ever expose him to the stand? They did not. They did not then, and they did not yet again in the February 2012 trial, although Palmer was literally right outside courtroom 9 when the prosecution announced that they would have no rebuttal. This defendant and his family, my brother, and friends saw that man with their own eyes. I saw him with my own eyes, and we saw how he trembled in fear and at the prospect of being called to the stand. There is but one reason why we have seen this prosecution lie to this very court in closing arguments, and seen this prosecution dare not call Jacob Palmer in rebuttal. He, the son and nephew of 20-plus year Virginia Beach police veterans, killed Jack Corte and is getting away with it? Now let us begin with the information contained in both the prosecution and defense's interviews with Jacob Palmer. First and foremost, he lied to Carrie Kopnicki and was actually foolish enough to state to her that he stayed at the party all night, never left, and slept there. We already knew for a fact through the testimony of Mr. Reddy and Mrs. Barreto and through Mr. Palmer's phone records that Jacob Palmer was absolutely not at the party all night long. Why is Mr. Palmer lying in such a drastic fashion? For Mr. Palmer actually volunteered to the defense's investigator Al Donker on April 20th, 2009, that the defendant always wore his seatbelt, never let anybody drive his car, and that he wouldn't be surprised if the defendant hopped into the back seat after the impact. Mr. Donker interviews notes yet preserve his confusion as to why Mr. Palmer offered up this unsolicited information. What is most important to extract from that interview, however, is the fact that Mr. Palmer told Mr. Donker that he first found out about the accident through a 6 a.m. text from the defendant's brother, Colin Crockett, and myself. The defense, unfortunately for Mr. Palmer, is in progression of both Mr. Palmer's and Colin Crockett's text message records from that morning following the accident, and there is absolutely no such text on the records. In fact, there are no texts between the two men for the entirety of December 29, 2008. Why would Mr. Palmer lie about how he first found out about the accident? The answer is simple. He had to, because he first found out by crashing the defendant's vehicle into the tree, killing his best friend, and leaving the Mr. Crockett out to dry and let him take the blame. This is, however, isn't the only instance in which we can prove Mr. Palmer has lied about the first found out about the accident. Let us continue with his lies. In 2010 interview with Kathleen Fisher, Jacob Palmer's baby's mother, Mrs. Fisher told Mr. Donker that Jacob was at her house the next morning between 8 and 10 a.m. and that Jacob represented to her that he first found out about the accident, though, through a text from Kevin Rondorf, which supposedly read, "R.I.P. Jack Corte." However, most unfortunately for Mr. Palmer, the defense has also reviewed this period of time on his text message records, and between 7:46 and 10:27 a.m. there are no incoming or outgoing text messages. Had Mr. Palmer been held accountable for these massive lies on the stand, there is a much greater chance that his jury, however unreasonable, would have been completely unable to deny after a week of evidence against him, accumulating in his self-incriminating testimony that he was the driver of the vehicle on the night in question. Yet, the things that could have been but were not presented before the court do not stop here. It came to the attention of the defense on May 26, 2011, the evening after Mr. Crockett was falsely accused of involuntary manslaughter for the first time, that Jacob Palmer had confessed his role in the case to his longtime girlfriend, Nicole Vaughn, and that his Mrs. Vaughn entrusted this information to her best friend, Tori Miranda. When Mr. Donker went out to interview Mrs. Miranda at her place of employment after receiving this news, she very unhesitatingly admitted to what she had been told by her best friend, despite not even knowing the defendant and being good friends with Mr. Palmer alone. This conversation was recorded, and I'll show you that conversation right now.
Yeah, she's told me that before, but
She told you what?
She told me that Jacob was involved and that he was driving the car. I don't really know what happened, but I mean,
Of course
he's
not. Of course not.
said to me about it before, and we've talked, and I mean,
He's talked to you about it?
not Jacob, but
Nikki has? So he probably told her some time ago.
She told me that Jacob was involved and that he was driving the car. She told me that Jacob was involved and that he was driving the car.
And all of these things that I've just told you have just proven and backed up everything that I've said. And I want you to decide for yourself what had happened. Jacob Palmer, justice is coming after you.